decision. And next is about the access to birth-related information by adoptees. Again, this is something that we have been talking a lot about in the field, and in general, I am in agreement with the proposed amendment. But if we look at the scope of this article, we see that there's a lot of protection of the privacy of the biological parents, and already currently the adoption agencies, without the consent of the biological parents, are often unable to provide information to adoptees looking for their biological parents. And here it says consent by the biological parent at the time that the child was given up for adoption, but often the children who were adopted would go on looking for their biological parents 20 years after or 30 years after their birth. So maybe we should modify this time limit. So if the biological parents did not give a consent to information disclosure, then maybe based on a court trial or court decision, we should give opportunity to adoptees to nevertheless seek their biological parents. Next is about the Central Information Center and the role of the adoption agencies. I actually was involved in an adoption agency before, so I pretty much agree with many of the things that are laid out in this amendment, but in terms of role, I think there are certain roles that the adoption service providers can play, and there needs to be certain roles designated for the Central Information Center. So if you look at the various functions designated for these institutions, the Central Information Center can evaluate and make adjustments. And if we were to establish this central center as a private institution, then this would not be able to perform the role of adjustment and evaluation. So I think we need further discussion on this. And the next is about the guardian's responsibility and social welfare services. And I have been involved in post-adoption services as well, and this is something that I feel very strongly about, and I am very happy that some articles have been stipulated in the amendments regarding the post-adoption services. And I think there needs to be stronger legislative framework for assisting the adoptees in search of their biological parents. While there is emphasis on supporting the adoptees to search for biological parents, I think there is a lack of inclusion of criminal records here. So I think we need to add criminal records as well so that this kind of information can be accessed. I am pressed for time right now, so in closing, I would like to say that since my discussion paper is in the booklet, you can refer to that, and maybe I can address some questions at the Q&A session. Finally, in providing support for medical expenses and child rearing for disabled children, the definition of disability, whether physical or mental, and if right now we provide just fixed rate subsidy for children with disabilities, but we need to take into consideration the varying degrees of physical or mental disabilities. So certain families that have adopted children with severe disabilities should be given more subsidies, I feel. And I think that can really help these children with severe disabilities to find new home. And that is my wish. So perhaps instead of a fixed rate subsidy, we should have some varying amount of subsidization for the degree of disability.
I'm sorry that I'm not able to give you a sufficient time. Well, a lot of what our discussants are discussing are in the papers already, and I would like to give more opportunities to those in the floor. And Professor Hart talked about went into more specifics related to the biological parents, and she also talked about the services provided by the relevant agencies. In particular, she has emphasized the need to provide support for physically disabled children. Next, we are going to ask Ms. Boksun Park of our institute to do the discussion. Good afternoon, my name is Boksun Park. Unlike our three discussants, I do not have experience in the field, so what I discussed with may not completely reflect the field. I would like to thank Professor Hall for her presentation. In her presentation, she said that this special law or the special act, despite the 9 different amendments, has not been able to completely enhance the welfare of the adopted children and the adoptee families. And she has talked about some of the problems in the current Adoption Act in Korea, and what are some of the problems in this act when compared to the Hague Convention. And she said that there should be, she said that in the amendment there's a stringent qualification for the adoptive parents, and about conducting a home study, and about having no criminal records in order to be able to adopt the children. And I do agree with many of the things that she said. However, I do have a few questions, and so by asking my questions, I would like to end my discussion. And I think there was some confusion in terms of age. In her presentation, the child, we are here in Korea trying to establish a child and adolescent welfare act, and the so-called subject in this act has age of that they have been increased to 19 years old. And she said that our Adoption Act should also increase the age to 19. And that, I think she made a mistake in terms of the number of article. And also on page 17, she made a mistake on the age 18, but on page 26 it says 19. So that's a confusion. And I think Professor Hall is trying to say 19, but I understood it to be 18. So the act describes children that is under the age of 19, and however, those who have access to the information is supposed to be under age 18. So I was going to ask a question in regards to discrepancy between the ages, but it seems that the mistakes have been made in printing, and that's why I have decided not to ask this question. And in our current Korean Civil Code, the adult is above the age of 20. And if the civil code, if the age is going to be 19, I guess it's not a problem, but it's about the information access. And also in this information access law, I wonder if you also include those who are adopted, fully adopted.